the Minnesota Senate Commerce and Consumer Protection Committee to order on Thursday, April 10th, 2025. And on our agenda today is Senate File 2216, Senator Klein.
Thank you, Chair and members. We heard and went through Senate File 2216 with an A6 delete everything amendment, which was adopted earlier this week. It is now time to offer amendments, and I would like to start, Madam Chair, with 3 amendments of my own. I would offer the A28 amendment.
All right, Senator Klein offers the A28, which I believe is in our materials. Senator Klein, to your amendment.
Madam Chair, this is a series of small policy adjustments to several aspects of the bill. These are non-controversial and agreed upon by all parties. We thought it would save committee time to combine them in a single amendment, and I believe Council, Mr. Huddela and Ms. Siverson can walk us through what they entail.
Ms. Severson.
Thank you, Madam Chair and members. I'll start at the beginning on lines 1.3 to 1.8 of the A28. Previously, this section 13 that's being deleted on page 19 of the A6 was amending an effective date from last session to clarify what section 65A.3025 applied to. However, it was requested by the reviser that we not amend the effective date and just redraft it as uncoded law, which is what you now see on lines 1.4 to 1.8. It has the same effect, it's just done in a different way.
Mr. Huddela.
Thank you, Madam Chair. Committee members, lines 1.9 all the way to 2.33 of the amendment simply make technical changes to certain Department of Commerce language on Medicare supplement policies. Specifically, it moves language into a new paragraph C, makes minor edits to clarify that language, and then also makes conforming changes within that community rates subdivision. Moving all the way down to page 2, specifically line 2.34, that eliminates a sentence drawn from Senate File 1407. That sentence provides that a legislator, when notifying the Commerce or HHS committee chair of an anticipated mandated health benefit proposal, is not required to provide the specific text of the mandated health benefit proposal.
Ms. Severson.
Thank you, Madam Chair. And then going on to page 3, the first 2 lines, 3.1 and 3.2, are adding in some language to section 31 and sections 32. These 2 sections did not have the same language as far as what's necessary between a proper application and the applicable fees, so it just lines up the language. And this is also reflected in another section of law, but this just is a clarifying change to make it clear that you need a proper application and you also need to have payment of applicable fees. Then on line 3.3, we're changing the effective day of termination from the day of notice from 31 to 30 days. And then on 3.4 to 3.5, this is another reviser request to include this instruction to amend the title accordingly. This is a standard instruction that's usually included, but just was missed on the A6 amendment.
All right. Thank you, Council. Senator Rasmussen.
Thank you, Madam Chair. I have a question looking at page 1, line 29 and 30. And I know when we were talking about the Medigap penalty in the original bill, I believe it's set at 10%. And I guess one question I have is, wouldn't this language allow Commerce to set that lower than 10%? Am I reading that right, or am I missing something?
Mr. Huddela.
Thank you, Madam Chair. Senator Rasmussen, yes, your reading is correct. It would allow them to set it at a rate lower than 10%.
Senator Rasmussen.
Thank you, Madam Chair, and thank you, Mr. Huddela, for that answer. And I guess, and I'll have an amendment on this later today, and I think it's an important topic where having the 10% we've heard from health insurers could really have a negative impact on the Medigap market. And for the couple 100,000 Minnesotans who rely on Medigap coverage, we're hearing estimates that having at the 10% could increase premiums up to 90% for these Minnesotans, because one of the key parts of insurance is you have to make sure you don't have a selection bias. And so allowing people to sign up late when they might need that coverage can really have a detrimental impact on the soundness of that market. And I guess this amendment before the committee would actually take it potentially lower than 10%. You could have Commerce, in my understanding with this language, could have it at 0%. And so that's one concern that I have with this. I think there's other things that are technical fixes, but that's one item that I'm concerned about. And so just wanted to flag that for the committee, because I think it's important that we have a strong Medigap market that can serve Minnesotans with those needs.
Any other questions or comments from members of the committee as to the A28 amendment? All right. All right, seeing none, all in favor of the A28 amendment, say aye. Aye. Any opposed, say no. All right, the motion prevails and the amendment is adopted. Senator Klein, you had another amendment?
Madam Chair, the A27, purely technical, eliminates two words at line 1.15 at the reviser's request. We didn't make it in time for the reviser's bill.
All right, any questions or comments on the A27 amendment from members of the committee? Seeing none, all those in favor of the A27 amendment, say aye.
Aye.
Any opposed, say no. Motion carries and the amendment is adopted. Senator Klein, you had another amendment?
My last amendment, the A26, Madam Chair, I offer.
A26. Senator Klein, to your amendment.
Madam Chair, this deals with the HOA language that we heard earlier this session from Senator Pa and Senator Marty. There was some pushback, or I should say input, from the HOA Association. It was considered friendly by Senator Pa, the author of the bill. This is compromise language that puts this bill in the order that both parties wish.
All right, any questions or comments from members of the committee with regard to the A26 amendment? All right, seeing none, all those in favor of the A26 amendment, say aye. Aye. Any opposed, say no. Motion carries and the amendment is adopted. Any further amendments from you, Chair Klein? All right, Senator Dames.
Thank you, Madam Chair. So you will take other amendments at this point then?
Yes, you have an amendment, I understand.
I have two.
Okay,
First one is the A7 amendment, Madam Chair.
all right.
The A7 is in your packet.
I do have it in front of me. Senator Dames, to your amendment.
So this amendment makes a technical change to the Guarantee Association's language in Article 2, Section 9. So this amendment makes technical change to Guarantee Association's language in Article 2, Section 9 to more accurately reflect how the association operates. The amendment simply replaces the term Board of Directors with Association because it is the association and not the board that administers the insolvent insurer's claims. So it's just a technical amendment.
Senator Klein, any thoughts on the A7?
Friendly amendment.
All right, any discussion from members of the committee on the A7? Seeing none, all those in favor of the A7 say aye.
Aye.
Any opposed, say no. Motion carries and the amendment is adopted. Senator Dames, to your next
And
amendment.
Thank you, Madam Chair. The next amendment is the A24 amendment, and I do not believe that's in the packet. I think that needs to be handed out.
All right, the A24 will be distributed. Okay. All right, while that's being handed out, Senator Dames, can you explain your amendment?
Yes, thank you, ma'am. This amendment deals with surplus lines as well as the FAIR Plan and how they fit together. So currently, under the FAIR Plan, it started out at 500,000 as far as owner-occupied dwellings values. So anything up to 500,000 could be insured in the FAIR Plan. Over the years, that's moved up to 1.9 million. Where the problem comes about is the FAIR Plan does not take all homes. So then if a home is not accepted by FAIR Plan, it could step over into the surplus lines market. Currently, the surplus lines market would not be eligible to homeowners that have a home that's valued over $1.9 million. So what this does, and this is an agreement that's come forward between the different folks negotiating on this, and as I understand, the department is on board with this. So what it would do is it would remove the multiplier and take down the FAIR Plan down to 500,000, which would allow surplus lines then to insure some of these homes that the FAIR Plan would not insure over the $500,000. So what it does is it gives another avenue for folks that are having trouble finding plans for their home, to place their homes for insurance. However, keep in mind that these do not compete. When you get into the risk lines, you're not looking for competition, you're looking for places to buy insurance. And so very seldom are you going to find that the surplus lines are going to be competing with the FAIR Plan. So I would ask support of this, and it is my understanding that there's peace in the valley on this bill at this point.
Thank you, Senator Dames, and I'm going to let you know I've learned way more about surplus lines in the last couple of days than I ever knew about. So thank you for bringing this issue to at least my attention. Senator Klein, any thoughts on the A24?
Senator Seeberger, like yourself, I took a crash course in surplus lines over the last week. My first instinct was to say this issue of surplus lines came to this committee very late in the session. It's a complex issue. It deals with the property and casualty market, which is under stress, and we need to learn a lot more about it. It should be introduced as a bill, but in conversations with Senator Frentz and the advocates and the department, it seems as though it would be reasonable for us to do something in the form of this amendment today to get placeholder language in place, continue to educate the committee about it with a committee hearing, maybe after deadline, and then try to work on this in conference so something can be done this year. Members, just here's my simple understanding of surplus lines. As it becomes more difficult for people to obtain property and casualty insurance on their homes, there is a line of products available that are less regulated called surplus lines, are more expensive. Agents are sort of directed, incentivized to steer people towards the traditional market before the surplus market. And right now, those barriers to sort of accessing without incentives, the surplus market is set at $1.8 million for a house, which is very few houses. This lowers that down to $500,000, making surplus lines a little more accessible to Minnesotans. Again, members, we'll learn more about this in a full committee hearing, but for today, I ask your support of the A24.
Any questions or comments from members of the committee? Seeing none, all those in favor of the A24 say aye.
Aye.
Any opposed say no. Motion carries and the amendment is adopted. All right, any other amendments to the Senate File 2216 as amended? Senator Rasmussen.
Thank you, Madam Chair. I'd like to offer the A23.
All right, Senator Rasmussen offers the A23, which is in our packets. Senator Rasmussen, to your amendment.
Thank you, Madam Chair. And just to orientate members of the committee, this is dealing with the carrier of last resort obligations bill that this committee and the Senate Energy Committee had a hearing on. And this is some final technical changes that gets to true peace in the valley between all stakeholders. The telcos have reviewed this, the cable companies, Department of Commerce, and the PUC, and they're comfortable that with this amendment adopted, that there is no formal opposition to the bill. So I appreciate this committee's work and Senator Klein and Senator Frentz for working with me on helping have an orderly transition to newer technologies within the telco space.
Senator Klein, your thoughts on the A23 amendment?
Friendly amendment.
All right, any questions or comments on the A23? Senator Frentz.
Thank you, Madam Chair, and thank you, Senator Rasmussen and Senator Klein. I agree. This was something that did come over to Energy, and I want to thank the advocates for working it out. As best I can tell, they did find an agreement that everyone can live with, so I'll be a yes vote on the amendment.
Any other questions or comments on the A23? Seeing none, all those in favor of the A23 say aye.
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 Any opposed say no. Motion carries and the A23 is adopted. Any other amendments from any members of the committee? Senator Rasmussen.
Thank you, Madam Chair. I'd like to move the A20.
Senator Rasmussen offers the A20, which is also in our packet. To your amendment, Senator Rasmussen.
Thank you, Madam Chair. In the Department of Commerce's budget proposal, one of the modifications that they'd like to do and actually had booked some savings for it within the governor's plan is changing our state benchmark plan. And I am worried that this could be an additional avenue to add new health insurance mandates without legislative approval. And so the A20 would clarify that if they're going to be adding new health insurance mandates that would trigger a 62J process, that it has to come to the legislature for approval. And I think this just puts a marker on this bill that we want to make sure that we understand how Commerce is planning on proceeding with changing our state benchmark plan.
Senator Klein, your thoughts on the A20?
Yeah, within the governor's budget, there is a plan to re-benchmark some of our current mandated coverages, and he books it as a cost savings, suggesting that they would stop making defrayal payments for those disease entities. I share your concern about doing that. In discussions with the Department of Commerce, they feel like turning over benchmarking to the legislature would be cumbersome and run into some tactical difficulties. However, I would be supportive of an idea that allowed the Department of Commerce to re-benchmark but maintained sort of the financial control over defrayals within the legislature. And so I'm going to urge a no vote on this today from committee members, but I would be eager to work with Senator Rasmussen going forward as we go to finance and then to the floor on something that might accomplish that end.
Senator Rasmussen.
Thank you, Madam Chair, and appreciate the comments from the bill author and look forward to working with him to make sure that this doesn't become an avenue to add costly insurance mandates that could drive up the health insurance costs for Minnesotans and small businesses across the state. So I'll withdraw the amendment, but look forward to continuing to work with Senator Klein as this bill moves forward.
The A20 is withdrawn. Senator Rasmussen, did you have more amendments?
I do, Madam Chair.
All right. What's next?
Thank you, Madam Chair. I would move the A29 amendment. I believe this needs to be passed out, but I'm happy to explain it. I think it is posted, I believe, online. It is posted online.
All right. Staff will distribute the A29. While they're passing it out, will you explain to us what your A29 amendment does?
Yes, thank you, Madam Chair. So the A29 is dealing with some of the cannabis appropriations within this bill. And one of the promises that was made when recreational cannabis was legalized 2 years ago is that the tax revenue would be used for public health initiatives. And I think everyone has understood on a bipartisan basis that there are public health costs to cannabis usage, especially recreational cannabis usage. We also recognize the risk that it has to pregnant and breastfeeding mothers and the risk that's out there as well. And unfortunately, though, over the last couple of years, we have seen funding that was in the original bill get cut. And so one of those instances was about $3.6 million each year that was going to fund local and tribal public health grants. And then we also had money that was cut for prevention education program for pregnant and breastfeeding individuals. And so this would simply take some money from the Can Renew grants. It would still leave the vast majority of that funding in place, and it would bring it back to fund these public health initiatives that were in the original bill. And I think this is an important way to make sure that we're prioritizing public health and safety for Minnesotans and keeping the promises that were made with the original bill. And again, I'm not saying that the Can Renew grants aren't worthwhile or there aren't some good purposes, but from the presentation from OCM, I just don't think they're as well defined. And I think these dollars could be better prioritized, making sure that our public health entities have the resources they need to educate Minnesotans on the negative consequences of cannabis usage.
Senator Klein, your thoughts on the A29?
Madam Chair, this is my first blush at this amendment. Members, so this would redirect Can Renew grants money that's sort of directed towards communities that have been felt to be victimized or targeted by cannabis enforcement in years past, and it would take those monies and redirect them to sort of public health initiatives. I think it's worth a discussion. Since I haven't had the time to sort of evaluate sort of the balance of funds and changing them, I will oppose it for today, but I'm eager to continue the discussion.
Senator Duckworth.
Thank you, Madam Chair. I appreciate it. I just kind of want to back up Senator Rasmussen, so to speak, and this really isn't directed at the author of the bill, but I've begun to see a pattern specific to the legislation that was passed a couple years ago as it relates to legalizing cannabis in Minnesota, as well as other bills that essentially has begun to walk back some pretty important aspects of those bills that were put in there to try to keep people safe and mitigate some of the risks inherent to those pieces of legislation. I get it. We've got a $6 billion deficit that we have to figure out. That being said, I think we owe it to ourselves to find a way to still try to preserve some of the elements of those pieces of legislation when they were passed, especially as it relates to safety, education, things of those nature. Again, it's not directed at you, Senator Klein. You've got a target. You're working within it. That being said, if a can renew budget line item is $15, $20 million or so, and we have the chance to preserve some aspects of those legislation that I think the public thought were probably pretty important from a safety and educational standpoint, that it's worth giving some consideration to. So I appreciate your openness to at least continuing to dialogue on that. Thank you.
Senator Rasmussen.
Thank you, Madam Chair. And I just wanted to ask, we're lucky here to have the chair of the Health Committee, and actually in some ways this amendment is trying to help Chair Wickland with her target, because the cuts that were originally made, that 3.6 million and then the additional money that is been proposed for this year would be dollars that would go back into these public health programs. And so I just wanted, Madam Chair, to see if Senator Wickland had any context she could provide around what's been happening with this public health funding that was supposed to be coming from the cannabis bill.
Senator Wickland, do you have any wisdom to share?
Thank you, Madam Chair. Senator Rasmussen, we examined the, MDH made some additional cuts recently, in the revised budget to some of the grant programs. We were able to restore or not accept a couple of those because we were concerned about the importance of funding grant programs like this. I don't have the spreadsheet with me, but I think clearly we feel that local public health is under attack in terms of federal reductions, and the department is certainly feeling that their federal money is at risk. I think that the programs that Senator Rasmussen has identified are definitely very important, and I do feel like these grants should be going to, public health and related to cannabis and, related to pregnant and breastfeeding individuals. It's really their important programs. I think that the chair has identified that he's not aware of this amendment and not willing to accept it, but I do. I think that given the federal cuts and our lean, HHS budget, we will be looking for ways that we can maintain local public health grants. So, thank you.
Senator Rasmussen.
Thank you, Madam Chair. And I would defer to Senator Klein, and we can continue this conversation if you'd like me to withdraw the amendment. But I think when we're facing a $6 billion deficit, there's just trade-offs, right? And I think this is something that we should be prioritizing from those tax revenues that are coming from the sale of recreational cannabis to make sure that we're trying to address some of the harms that I think we're all aware of with cannabis usage.
Senator Klein.
Madam Chair, I will say that I am very receptive to the idea of adjusting these funds and seeing if we can't backfill some public health lost dollars. I feel uncomfortable making the decision at the table today without touching in with the Office of Cannabis Management or other interested parties. If you would withdraw the amendment, Senator Rasmussen, I think we could probably come to an arrangement.
Thank you, Madam Chair. I'll withdraw the A29.
All right, the A29 is withdrawn. Any further amendments, Senator Rasmussen?
Thank you, Madam Chair. I can go to, I'll let Senator Latz do some, and then I'll do some more.
I thought you were done. Go ahead.
All right, Senator Rasmussen, why don't
Thank
you
you,
go?
Madam Chair. I will move the A17.
Senator Rasmussen moves the A17, which is contained in our packet. Senator Rasmussen, to-year amendment.
Thank you, Madam Chair. The A17 is in regards to the changes to the 62J process that is within this bill. And I'll go back. One of the reasons I care a lot about the 62J process was when I started in the legislature, we would have health insurance mandate day, we'd have these different proposals, and they were all good things that were being proposed, but we didn't know what the trade-offs or the costs were. And so I enjoyed, at that time, working with Representative Elkins in the other chamber to come up with this 62J process and to get that passed into law. And I'm worried that some of the provisions in the current Omnibus bill will roll back the comprehensiveness of the 62J process and could make it easier for legislators and others to avoid it. And I think even though the 62J process has been a work in progress, I think it has provided a lot more helpful information for this committee and for the legislature to be discerning around which health insurance mandates should be put into law and which ones are maybe not the best, in the best interest of Minnesotans and the cost of care. And so this amendment would address the main concerns that Senator Mann brought up in her committee or during her presentation, which was making sure that we have forms that are very clear that applicants can fill out for the Department of Commerce's process. And we also have provisions, if this amendment is adopted, for first-term legislators that are just coming in and might not have the time to meet the deadline since they haven't been elected yet. And so, again, this is, I think, would keep the 62J process strong, and I think actually could have the opportunity to make some reforms this year. I just worry that the bill in its current form isn't going to have that bipartisan support.
Senator Klein, your thoughts?
Thank you, Madam Chair. One of the hallmarks of the Commerce Committee is that when we have authors who bring forward legislation that they've sort of worked on extensively, the chair really tries to honor their intentions with that bill, barring any really unforeseen hurdles. We did adopt some compromise language agreed to by Senator Mann in the A28, but she has indicated that this A17 amendment goes too far and she would not support it. And I will back her up on that and urge a no vote on the A17.
All right, any other comments or questions on the A17 from members of the committee? All right, seeing none, all those in favor of the A17 say aye. Aye. Any opposed say no? No. The motion does not carry and the A17 is not adopted. Senator Latz, sorry to call you. I told him he would be next.
We all know sometimes it's hard to fit in lunch around here. So. Madam Chair, I'd like to offer the A21 amendment.
Senator Latz offers the A21, which is included in our packet. Senator Latz, to your amendment.
Madam Chair and members, this amendment applies to the HOA portion of the bill. It does a couple of things. One is it narrows the application of the bill to residential homeowners associations, thereby excluding office condos and commercial type HOA situations. Secondly, it expands the privacy provisions in the bill for information that is maintained by the Department of Commerce to include the HOA itself, the management companies and their affiliates, all of which could have information which gets transmitted as a part of the Department of Commerce's oversight to the Department of Commerce. If that information is not maintained as private data, then it is frankly proprietary, important proprietary business information that would be public and available to all their competitors as well. So it seems to me that's would be quite unfair. Commerce would still have the ability to do their enforcement because they'd have the information and could base their enforcement on it, but it doesn't expose all of this proprietary business data to public and to the competitors. And then the third portion of this amendment deletes the Attorney General's office from the enforcement elements of this, of the bill. It would leave it only with the Department of Commerce to follow up on enforcement. This bill provides for the Attorney General's office to have authority under Section 8.31 as a basically the public interest attorney. 8.31 is very expansive, also allows for private rights of action acting in the public interest. And so it's pretty substantial. And it seems to me that the Department of Commerce has ample enforcement authority to enforce the meaningful provisions of this HOA bill without adding to the Attorney General's responsibilities or expanding that into private lawsuits as well. My understanding is that the Attorney General's office supports removing them from the enforcement provisions. Any further questions or details, Mr. Carlson, I believe, is present here, who's been working on these issues as well.
Senator Klein, your thoughts on the 821?
Thank you, Madam Chair. When these issues came before us, as we did the HOA bill, I raised the question as to why they had not been addressed in the Judiciary Committee. I'm now satisfied that the chairman of the Judiciary Committee feels that these are reasonable alterations in the bill, and I support the 821.
All right. I see Mr. Carlson in the audience, teed up and ready to offer input. Mr. Carlson, Senator Klein is okay with this amendment. Do you have anything more to add?
Happy to answer questions, Madam Chair. There are some very sensitive public data that, or private data that would be released with this, including our federal tax ID numbers, which I don't think anyone wants to put on a searchable database. Appreciate your support.
Any questions or comments from members of the committee on the A21? Senator Duckworth.
Thank you. Just briefly, Madam Chair. I guess first and foremost, Senator Klein, the HOA ombudsman person is included in this bill, right? Okay, so to me, it would kind of make sense that the Commerce Department would be the one to sort of take a look at this rather than the Attorney General. But last and not least, but for Mr. Carlson maybe, the data classification and keeping it private, I just want to make sure, I assume this is not the intended impact. Oftentimes in a real estate transaction, the sharing of information as it relates to an association, whether it be financials, other statements, tax documents, bylaws, things of that nature, CIC certification documents, that is required to be transferred among people. And sometimes it does get displayed in places publicly. So I just want to make sure that if we do a data classification, which seems specific to board member contact information, it doesn't somehow get interpreted to apply to things that do need to get passed back and forth between parties to a real estate transaction when they're going to sell property. Is that your understanding?
Mr. Carlson?
Madam Chairman, Senator Duckworth, absolutely.
Okay.
This only applies to the registry information that Commerce collects. Everything else in your declarations that go along with your real estate transaction, this doesn't touch any of that.
Very good, thank you.
Senator Rasmussen.
Thank you, Madam Chair. A question for Mr. Carlson. I know one of the items that Senator Pah brought up was sometimes people don't know who to contact within their HOA, and just making sure that if they had a problem with the management company or something like that, that they'd be able to get in contact. Would this amendment affect their ability to be able to work with the ombuds person to get in contact with HOA management? I just want to understand how this impacts that.
Mr. Carlson.
Madam Chair and Senator Rasmussen, I don't think it impacts that at all. That information should be available to every unit owner. And so I don't think that this impacts that at all. But once the registry, if it moves forward and is established, the ombudsman would have that information. It just wouldn't be searchable on a public database, but they would have the data of the name of the association, who's in charge of it, what the management company is.
Any other questions or comments on the 821? Seeing none, all those in favor of the 821 say aye.
Aye.
Any opposed say no. Motion carries and the amendment is adopted. Senator Latz, you had one more?
Yes, Madam Chair, I'd like to offer the A22 amendment.
Senator Latz offers the A22, which is in our packet. Senator Latz, to your amendment.
Madam Chair, this amendment does the same thing to the data that is maintained, that will be maintained by the Ombudsperson's office that we just did to the data maintained by the Commerce Department. Would expand the private classification to commercial entities, the HOA management company, and the HOAs themselves.
Senator Klein, any thoughts on the A22?
Support the A22.
Any questions or comments from members of the committee on the A22? Seeing none, all those in favor of the A22 say aye.
Aye.
Any opposed say no. Motion carries and the A22 is adopted.
Thank you, Madam Chair, members.
Senator Rasmussen.
Thank you, Madam Chair. I'd like to move the A18.
Senator Rasmussen moves the A18, which is included in our packet. Senator Rasmussen, to your amendment.
Thank you, Madam Chair. The A18 gets at this issue that we've talked about a little bit on this committee over the Medigap language that's in this bill. And again, this is actually a bill that Senator the A18 is a Senator Draheim bill that I think has bipartisan co-authorship and support in both chambers. And again, this is making sure that we have a healthy Medigap market there for our seniors who need it. And we've just heard a lot of feedback that the current Commerce proposal, and especially since the amendment was adopted today, that effectively Commerce could decide that there is zero penalty for someone who is missing the window and when they should be signing up for Medigap coverage, which can have a really adverse impact on the health of that insurance market and could drive premiums up as much as 90% for the 200,000 Minnesotans who currently get Medigap coverage. And so I'm offering this amendment today as an opportunity to preserve the health of this market for Minnesotans and to make sure that we don't just allow individuals in and out of the market when they need it, which is contrary to just basic principles of insurance.
Senator Klein.
Yeah, thank you, Madam Chair. And I think we're all sort of guessing in the dark on this one a little bit. The department feels that their 10% barrier to sort of later enrollment will be sufficient to keep the market stable. Complete reversal of the Medigap things that we did 2 years ago has been represented as, blocking a lot of people out of this marketplace unfairly. I'm satisfied that the compromise language proposed by the department, the 10% penalty for late enrollment, is satisfactory, but I am open to revisiting it in future years if I'm proved wrong. At this time, I'm going to oppose the 18.
Senator Rasmussen.
Thank you, Madam Chair. One of the other points I wanted to make was this amendment would still protect existing guaranteed issue protections for Minnesotans with pre-existing conditions. And so we are trying to have language in there for qualifying events that could make someone eligible for this kind of product. What we just don't want is people to be able to just get it when they need it, which is going to lead to higher insurance premiums. I'm happy to work with Senator Klein and the Department of Commerce on this issue going forward. And I just think it's a really important thing for us to get right before this gets passed into law. But with that, Madam Chair, I'll withdraw the A18.
The A18 is withdrawn. Senator Rasmussen.
That's it for me, Madam Chair.
Oh,
Yes.
okay.
I can offer more if you like, but
No, we're good. Any other amendments? Senator Friends.
Thank you, Madam Chair. I'd like to offer the A25 amendment.
Senator Friends offers the A25, which is in our packet. Senator Friends, to your amendment.
Thank you, Madam Chair. Thank you, Senator Klein. This was brought to me by Minnesota Municipal Utilities Association and relates to clarification of when it's okay for a utility to sell electricity related to electric vehicle charging. In the amendment, as you can see, and Mr. Hudala can talk to it, or Ms. Severson if we need to, basically what it says is a retail seller of electricity that's used to recharge a battery is not otherwise a public utility under this chapter is not in violation for doing that as long as the electricity that they sell was generated there. And the significance here, Madam Chair and members, is just that, as many of you know, our municipal utilities and co-ops are not investor-owned and in the regulated utility class. So simply making clear that if your electric vehicle charging station is in the location of a co-op or municipality, that it would be legal. I think this is extra safe. I don't think they would be in trouble, but it was brought to me by the director and just said, can you clear this up? And with that, I agreed to bring the amendment. I have not had too much of a chance to talk to Senator Klein about it, but as best I can judge as Senator, it meets my strict standards of amendment scrutiny. And with that, I'd hope members would consider supporting it.
Senator Klein, any thoughts on the A25?
Madam Chair and Senator Frantz, do you know of any opposition to the amendment you're proposing?
Senator Frantz.
Thank you, Madam Chair. Thank you, Senator Klein. I do not.
Senator Klein.
Friendly amendment.
Any questions or comments from members of the committee on the A25? Seeing none, all those in favor of the A25 say aye.
Aye.
Any opposed say no. Motion carries and A25 is adopted. Any other amendments from members of our committee? Any questions or comments on the Senate File 2216 as amended? Senator Dames.
Thank you, Madam Chair, and I think it's unfortunate that the amendment that Senator Rasmussen just had, that we couldn't get the support for that. Wasn't that many years ago where if you wanted to buy a health policy or a Medicare policy, it didn't make any difference what time of the day or what time of the year or what month of the year, you just went into your local agent or online and you purchased it. And they found that that was one of the major cost drivers to health insurance, was the fact that people were able to come in and buy insurance, and at that time, we were right in that transition of to where you could exclude certain things from coverage. And once that transition was made, it was found that it was very expensive for health insurance companies when they were still taking open enrollment any time during the year. And so I think it's unfortunate that we're going to wait and see in a couple of years and see what happens if we go to open enrollment, and this is the opening of the door to that. You can open enroll as long as you pay a 10% fee or less, depending on what the Department of Commerce decides. And so I think that that is setting a bad precedence here, and I think we're going to be going down a road in a couple of years from now. We're going to wonder what happened and how we're going to get back out of it. So I think that's something we need to take a closer look at. Thank you, Madam Chair.
Any other questions or comments from members of the committee? Senator Klein, any final thoughts?
Madam Chair, I'd like to make a motion.
Go ahead and, if you would like to move your bill.
I move that Senate File 2216 is amended, be recommended to pass, and be referred to the Committee on Finance, and that nonpartisan staff be allowed to make any technical changes reflecting the will of the committee.
On that motion, all those in favor say aye.
Aye.
Any opposed say no.
No.
The motion carries, and Senate File 2216 as amended is recommended to pass and re-referred to the Finance Committee. And there being no further business before the committee, we are adjourned.